Hi, my name is Devorah Grazer, and I'm here today to talk about the recent Supreme Court decision, Alice Corp versus CLS Bank International, which potentially limits the scope of software patent protection in the US. The story begins with Alice Corp, which had 4 patents to protect risk in electronic trading, specifically the risk of completion, that one side of a trade would do its part and the other side would not. They sued CLS Bank International for infringement of these patents. The case went all the way up to the Supreme Court. The Supreme Court decision invalidated software patents which relate to an abstract idea or which do not have an innovative technological concept. So what does this mean? Well, first, with regard to the abstract idea, the Supreme Court said that the invention described in the patent had to be sufficiently concrete. It had to be clearly embodied as software or as a system including software components. It also had to be clear that it was a technology and not just a general idea. With regard to the innovative underlying concept in the patent, again, the Supreme Court is emphasizing the role of human creativity and of technology. The Supreme Court said that the technology described in the patent had to be sufficiently inventive, that is, innovative, in order to be granted a software patent. Unfortunately, the decision did not lead to any specific bright-line tests, and in fact, the judges said they rejected such a test, as it would make it more difficult for future innovators to obtain patent protection. So what does it all mean? Well, ultimately, the meaning of the Alice Supreme Court decision will depend on how lower courts interpret it. For example, in Ultramershal versus Hulu, patents which were covering software that enabled ads to be inserted in television shows were held to be invalid. Why? Because they related to an abstract idea. They weren't sufficiently concrete, and the Supreme Court did not, the District Court, did not see any technology involved. However, this certainly doesn't mean that all software patents were invalidated by this decision. And in fact, in another case at another district court, patents drawn to California Institute of Technology versus Hughes Communication were held to be valid. Now, these patents were drawn to software for error correction in data through data encoding and decoding, and the judge held them to be valid as they covered a technology. This means that certainly not all software patents are invalidated by the Supreme Court decision, not even all business method patents, which are patents drawn to a general software concept. Instead, it is very important to write your patent applications so that the patents will be held valid. Well, how can you do this? Confused? Here is where you need to consult a patent expert. There are 2 important points to remember about these decisions. First, the technology itself has to be inventive, not just the underlying idea or concept that the technology is used for. You need to describe the technology clearly. Second, the way the patent is written is very important. Not just describing the technology clearly, but also the specific wording, the specific way in which the patent protection is requested can mean the difference between a valid patent and a patent that is not valid, or even worse, a patent that won't be granted by the US Patent and Trademark Office. This is true even if the underlying technology is inventive. This is why you need to consult a patent expert. Now, for more information on how you can be certain to cover your software idea with a valid patent, we have a downloadable tip sheet for you.